We're on for a special edition of Legal AF, crossover edition with Leah Litman, Professor Leah Litman of Strict Scrutiny. Can't think of anybody better to do a follow-up and a briefing for our audience about what just happened with the United States Supreme Court. And I want to call it, Leah, the Birthright citizenship case, but it's really now the nationwide injunction case, overturning, 100 years of precedent that allowed, without any objection, federal judges to meet the moment in giving remedy and giving relief, that if there was an extraordinary nationwide proclamation or abuse of power by a president, they could issue a nationwide injunction to meet him on that battlefield. Not so, says the United States MAGA majority right wing. Only the United States Supreme Court can make a universal declaration about an abuse of power. And Amy Coney Barrett writing, as you predicted, Amy Coney Barrett writing for the majority, the supermajority, goes through the whole history of universal injunctions and historical antecedents and precedents and all of this stuff, and says, where does it come from? Why are they allowed to do that? I don't know. There's dozens of cases in the annals of the Supreme Court that allow it and have always allowed it until they got the numbers. Now, let me just give the last part of the headline. Birthright citizenship, they did not on the merits make a ruling one way or the other about whether the 14th Amendment birthright citizenship can be overturned by an executive order. However, we're going to talk about what the lawyers now have to scramble to do in the three separate jurisdictions in order for babies that are now being born in red states that are not subject to these three injunctions, who now are in this purgatory of, am I a citizen? Do I get federal funding? Do I get health care? Do I get any of those programs? Is left in limbo by this callous MAGA Supreme Court. Okay, I'm done with my breathless introduction. Leah Litman, turning it over to you. What happened? What happened?
So I would call this case, you called it nationwide injunctions. I would call it the get out of Constitution free case, because basically what the Republican justices said is, when a private individual challenges a policy and that policy might be wildly illegal in violation of the Constitution and federal laws, a court cannot block that policy on a nationwide basis. So what that would mean is the executive branch could implement the policy as to other individuals who didn't sue. Now, there are going to be some exceptions to that we'll cover in a bit. But I think the top line thing is the Republican justices took away lower courts' most important, most effective tool to date in restraining the Trump administration and its illegal behavior. This is going to really transform civil rights litigation and what is happening on the ground with the Trump administration's policies. And the irony of this is just, it spilleth over, because of course the Biden administration was subject to nationwide injunction after nationwide injunction in cases that didn't warrant it. And they repeatedly asked the Supreme Court, guys, can you do something about this? The Republican justices declined to do so. And now, all of a sudden, 5 months into the Trump administration, they realize, oh, nationwide injunctions, yeah, they've basically been legally suspect all along. How convenient, sirs and madam. And it is just gross in its obvious hypocrisy. And I want to say more, but I'll just stop there for now.
No, that's good. So here's what's left in the ruins, the smoldering ashes of this decision. Federal district court judges and appellate court judges no longer have the power, other than for the parties that are in front of them, either by class action, which we'll talk about in a minute, or by just individual normal lawsuits, cannot fashion appropriate relief in order to oppose an out of control, or as Ketanji Brown Jackson wrote in her dissent, the law-free zone of a president who is just out of control. They no longer have that ability. Now, procedurally, and let me just read to our audience from Sotomayor's dissent, because she's doing a great job with these little Easter eggs in the last few decisions, giving guidance to and invitations to federal judges like Murphy in Massachusetts about what he should do about an injunction that was issued or a stay that was issued by the court, and now direction to the lawyers representing the parties in the three states. She says on page 44, I'll have to see what page of her dissent when we're done. Nevertheless, the parents of children covered by the citizenship order would be well advised to file promptly class action suits and to request temporary injunctive relief for the putative class pending class certification. Then citing back to Kavanaugh, for suits challenging policies as blatantly unlawful and harmful as the citizenship order. Moreover, lower courts would be wise to act swiftly on such requests for relief and to adjudicate the case as quickly as they can so as to enable this court's prompt review. That's the blueprint, right, Leah?
Yes. Yeah. No, exactly. So these cases are basically going to go back down to the lower courts, and the lower courts are going to have to make two different categories of determination. One is whether cases brought by private plaintiffs can proceed as class actions. And if so, how large is the class? Is it a nationwide class? In which case, nationwide relief might be appropriate. But the Supreme Court is going to end up reviewing all of those determinations because the decision to grant class certification is immediately appealable. So those are also going to be rushing up to the Supreme Court on the emergency docket. And then the second set of determinations are in cases brought by states. The Supreme Court held open the possibility that courts can grant nationwide relief where nationwide relief is necessary to remedy the full set of harms that states experience. But let's say a lower court decides, I need to give nationwide relief in this case to fully remedy a state's harms. You know, the Trump administration is going to run off to the Supreme Court and immediately ask it for an emergency review of that decision as well. So this is not going to relieve any pressure on the United States Supreme Court. Instead, it gives them these highly manipulable legal standards to basically selectively apply nationwide injunctions when they want to and deny them when they don't want. And again, given their pattern and practices, we all know, right, they are going to give the Trump administration a get out of law free card and then come down hard whenever Democratic administrations really do a tyranny, by which I mean cancel student debt relief.
Right. Yeah, I think you put that perfectly. So now we're going to see all of these attempted Rule 23 under the Rules of Civil Procedure class actions. Some judges foresaw this, like Boasberg, the chief judge in D.C. about the JGG case. He was like, let me just certify a quick class here, have a dollar bond, and then I'll grant relief. And then, of course, they were up in arms about that, as you said, you're anticipating that. We're getting beaten by two ends of the stick here. And then Ketanji, Amy Coney Barrett decides to take on Ketanji Brown Jackson, and I think she's outmatched, but just intellectually, jurisprudentially outmatched there. That's not a fair fight, except that Amy Coney Barrett's writing for the majority. So she takes on Ketanji Brown Jackson, who basically says, what do we have here? A lawless free zone where if you're in the good graces of the executive branch, meaning Trump, you're fine. But if you're poor and uneducated and you can't, quote unquote, lawyer up, she said, then you're at the whim of waiting around for the procedure to work its way through the appellate courts. In the meantime, the reality of this is the following, that except for Washington State, Maryland, and I think Massachusetts, or is it New Hampshire? I forget which one, Rhode Island. It's one of those up there. Except for those three states, if you're in a red state right now and you're about to have a baby, the executive order says, as it relates to your mother, that unless you fit this criteria, inconsistent with the 14th Amendment and 100 years of precedent, you're not an American citizen. So when your mother and your family goes and signs up for a Social Security card, for food stamps, for aid, for food, whatever it is, the red states can say, well, we're not enjoined. The executive order is the executive order.
Yep.
And so what are we going to do for the next 3 months, 6 months, 9 months, 2 years until the United States Supreme Court gets around to making a ruling on the merits of the case?
So we should say there is this initial 30-day period in which the executive order is not going to go into effect because the order said its effective date was 30 days after, its implementation, during which time the government was supposedly going to come up with these processes and procedures to determine how to implement the order. And so what's going to happen is during that 30-day window, the individual plaintiffs are going to quickly seek class certification. The states are quickly going to seek relief on a nationwide basis from the lower courts. My guess is some court somewhere is probably going to find that nationwide relief is warranted in that period, in which case it's going to set off, again, the race back to the United States Supreme Court. So my guess is that's what will happen. And And so the policy might again be preemptively blocked before it goes into effect. But we are staring down the possibility that after July 27th, 30 days after this ruling, it is no longer sufficient to establish citizenship for you to have a birth certificate that indicates I was born in the United States.
Yeah. And let's continue here. The other scary thing, I literally got, I sometimes I say this as sort of not literally, figuratively. I just got a chill down my throat listening to you because I just realized that the issue of 14th Amendment birthright citizenship could be decided by a Supreme Court on a short track, short fuse, skeletal record, 2 briefs, no oral argument, no deliberation, nothing, and they're going to make a ruling about the 14th Amendment birthright citizenship on the emergency docket?
I mean, I think that is a real possibility. The other possibility, though, would be for them to decline to stay a lower court decision awarding nationwide relief and then order further briefing and set the case for argument, as they kind of did on this nationwide injunction question. So that is a possibility.
That's very good. That's a very good observation. Yeah, that's right, because they did step out of the normal shadow docket procedure. And right, we had the oral argument up on Legal AF with people watching, and then you and I, of course, talked about it. That's a very good nuance that I missed. Yeah.
Yeah, but I guess my intuition is the fallout from this decision is likely going to be most significant in cases other than birthright citizenship, because if there is any case that warrants nationwide relief, it is birthright citizenship. Now, that's part of what makes the court's decision to even review this issue in this case so appalling. But again, I really think this is going to radically limit in other cases with respect to other policies, lower courts' ability to restrain the Trump administration. And that's going to give the Trump administration the power to implement their wildly illegal policies as to some individuals who were not able to obtain lawyers. And in some states, because they were Republican-led, they didn't opt to challenge the policies.
And the smugness of Amy Coney Barrett's decision, where she said, well, alleged abuse of power by the executive branch doesn't warrant abuse of power by the judicial branch. And if we can't find it in the Judiciary Act of 1789 or an historical, precedent going back to the Bill of Peace, then, she basically saying at least 50 years, if not more, of federal lower court practice has been illegal?
I mean, this passage of the opinion, it is either false or irrelevant. So it's confusing because when Justice Barrett says nothing like a universal injunction was available at the founding, or for that matter, thus under the Judiciary Act, federal courts lack authority to issue them. If that's true, right, then that would mean they also lack the power to do so in cases brought by states. So she doesn't seem to believe that logic. Or it means they're not actually going to allow lower courts to issue nationwide injunctions in cases involving states, in which case their carve out is meaningless. Like, it's just all jumbled and nonsense and hand wavy.
Yeah, absolutely. But I think you've done a very good briefing for our audience, and of course your audience on Strict Scrutiny, about what is the real world implication on the ground for the lawyers in the courtrooms starting now. And that, yes, and I saw that Amy Coney Barrett had said, well, even the executive branch has said they're not going to implement Section 2 of the executive order for another 30 days. Now, what you're hearing now is a mad scramble. Although, look, the one thing many things I admire about the law firms, public interest groups, and others that are in the resistance movement here against the Trump administration is nothing catches them flat-footed. They knew this was a possibility. They already have the papers drafted, right,
yes.
Leah?
Yeah. I'm sure. I am sure.
Within days, they will be filed. You and I will be talking about it, at different places. But your point is so well made about the implications on civil rights litigation and other types of things that we've always relied on the power of the federal courts to fashion appropriate relief. I mean, even I think it's Ketanji, it might be Sotomayor, I think it's Ketanji Brown Jackson, says, well, we just crapped, this is my paraphrase, we just crapped all over federal district court judges.
Yeah.
And now they have to put blinders on about the merits of the case, and about how They know it's unconstitutional. They've declared it unconstitutional. The only way, as you said, we can't think of a better case when you have what could have more nationwide implications than the declaration that somebody's birth certificate stamped in the United States is not sufficient for citizenship. What are you supposed to do? Well, in my state, really? We're up to 50 different lawsuits or hundreds of lawsuits in different districts and jurisdictions.
Yeah. So I want to highlight the passage that you were alluding to from Justice Jackson's dissent, because I think it's really remarkable. So she said, quote, "This court's complicity in the creation of a culture of disdain for lower courts, their rulings, and the law will surely hasten the downfall of our governing institutions." I mean, she is saying this court, right, they are enabling the Trump administration's attacks and refusal to comply with lower court decisions, again, by effectively saying, yep, you don't really have to. They were invalid anyways. And I think the use of the word complicity, which appears both in her dissent and Justice Sotomayor's, is also really telling, because what they are saying is this court, right, is using law to let the Trump administration get out from under the law, right? Using the law to enable lawlessness. And I think we should link this decision in the Birthright citizenship case, which again is making it harder to enforce the first sentence of the 14th Amendment, one of, the most core elements of our new constitutional order and civil rights, with their decision last year, which said, also states can enforce Section 3 of the 14th Amendment against Donald Trump, and the immunity decision, which said, by the way, you also can enforce criminal law against Donald Trump. The extent to which this court gives Republican justices, go ahead, you get to nullify, right, like the Reconstruction Amendments and our new civil rights, civil order is remarkable.
Yeah, and just to continue the weave here, the last Friday during the DVD decision that came, right, you have this one paragraph saying, no, it's okay, everything we said about habeas corpus and due process and notice, forget about
JK, psych.
Right, exactly, just kidding. You can put, I thought that was the jurisprudence that came out of the spring, but apparently it's not. Sotomayor basically said, I don't know if she used the word complicit, but she got pretty close in that dissent.
Yep.
Right? Where she said the abuse of power, the abuse of the power of this court to issue stays when there's no irreparable. By the way, what is the irreparable harm? Just blithely glossed over by Amy Coney Barrett in this new decision. There's irreparable harm. Okay, what is it? Well, that the judiciary is violating the Judiciary Act of 1789. That's the irreparable harm to the government in taking away potentially the right to protect children born in this country and their 14th Amendment birthright citizenship.
I mean, again, it is just incomprehensible, inexcusable, and I just think they are telling on themselves.
Yeah, very good. Now, let me segue for one thing as we end this collaborative hot take together. You're in a very interesting library or location right now that seems to only have Leah Litman's Lawless on the shelves. So
I am in my office.
Right.
And,
I love this library, by the way.
I learned you got to plug your book if you want that book to sell.
Times bestseller list. I'll take a small, the Hummingbird Theory. I can
Yeah, no. So the book is Lawless: How the Supreme Court Runs on Conservative Grievance, Fringe Theories, and Bad Vibes. And the opening chapter and the middle of the book, the backbone, talks about how the Supreme Court has let Republican presidents nullify the Reconstruction Amendments and place them above the law. And I just think the latest decision is part of that. And they basically, we're going to talk about this decision later, I think, but the Planned Parenthood case, the extent to which the court always manages to say Republican violations of the law face no consequence is stunning, because it's a Republican-led state who is alleged to have violated the federal Medicaid Act by booting Planned Parenthood from the Medicaid program. And you know what the Republican justices say? Oh, that just so happens to be a federal law you can't enforce. And okay, convenient. And you're telling me you can't enforce Section 3 of the 14th Amendment against Donald Trump? Yeah. Now you're telling me, right, you are going to make it practically more difficult to enforce Section 1 right after you nullify the Due Process Clause? I mean, come on, guys.
Now, Leah's going to be back with me. We're going to do something on Monday about that very case you just talked about. But I also want people to know that when Leah's not teaching constitutional law, one of our leading scholars there, and writing great books like you just saw, Lawless. She's also doing some amazing work on an hourly or daily basis on your Substack, right? And news articles that are coming out. Talk a little bit about what you're writing right now, what's out in the ether.
So the big project I'm working on right now is actually about the Trump administration's compliance or lack thereof with lower court orders. So I have a long law review article called Legalistic Noncompliance, where my co-author and I are arguing that the Trump administration deploys a bunch of specious legal arguments to insist they're complying with lower court decisions when in effect they are not, and how the Supreme Court is basically enabling their willingness to do so by pausing lower court decisions they haven't complied with and making the government pay no penalty for their refusal to comply with lower court orders.
They're rewarding bad behavior. Yep. Leah Litman, catch her on Strict Scrutiny and kind of on more regularly here on Legal AF. Leah, love to have you on. See you on Monday. We'll talk about that other Supreme Court case together.
Sounds great. Take care.
Can't get your fill of Legal AF? Me neither. That's why we formed the Legal AF Substack. Every time we mention something in a hot take, whether it's a court filing or a oral argument, come over to the Substack. You'll find the court filing and the oral argument there, including a daily roundup that I do called, wait for it, Morning AF. What else? All the other contributors from Legal AF are there as well. We got some new reporting. We got interviews. We got ad-free versions of the podcast and hot takes. Where? Legal AF on Substack. Come over now to free subscribe.